Be ready? Start. Now, in the present case, during the course of counting, an application was made to the Election Commission of India, wherein it has been stated that there was difference in signature of the presiding officer on the ballot papers stub. It was alleged that the candidate of Rashtriya Janata Dal had received 99% of the votes stub. In presence of another two booths, there were another application, although the same could not be produced in original, but there was allegation that there were irregularities in the signature of the presiding officer of booth number 22 stop. He filed another application for recounting before the Chief Election Commissioner, New Delhi, wherein grounds raised that the appellant lost the election by a margin of 265 votes, whereas number of votes rejected were 2000 and several votes were wrongly declared invalid stub. It was also alleged that there was irregularities in the signatures of the presiding officers of booth number 225 stop. But the learned judge found that a new case was showed to be developed that huge number of ballot papers of booth number 225 did not even bear the signatures of the presiding officers, and there was no distinguishing marks of the booths itself, where was not the case when they filed the petition before the returning officer or the Election Commission of India stop. The learned single judge, after examining the matter, found that the ground which was raised before the Election Commission of India and the ground which were raised by the appellant for recounting before the returning officer were different stop. But after going through the matter, he observed that the petition, in order to substantiate the case for recount, has to make a definite case with a specific allegation before the returning officer stop. He found that grounds showed to be raised before the returning officer and before the Election Commission were at variance stop. He further observed that if at the time of the counting the election agent raised objection and no good reasons were given by the returning officer for rejection, then that could make out a case for recounting under section 63 of the Act stop. But no such case was made out stop. Similarly, learned judge found that allegation during the trial also were not substantiated by oral or documentary evidence stop. It was also alleged that there was a difference in signature of the returning officer in the ballots stub. Subsequently, the case put up that the ballots did not bear the signature of the presiding officer at all, and there was no distinguishing marks of the booths in the ballots stub. Learned single judge found that the attempt was made to improve the case from stage to stage, therefore allegations lack bona fide and makes it doubtful stop. Learned single judge has also found that allegations of missing ballots and double marking brought out in the election petition, but no such evidence was led in support of the allegations stop stanza. Learned single judge further observed that while examining the documents and exhibits produced by the petitioner in the Form 20, there was interpolations stop. The learned judge observed that there is no scope of giving any relief to the election petitioner stop. Moreover, there is direct allegation against petitioner that he along with his persons had made this interpolations stop. The observation made by the learned single judge in para 29 of the order does not cast any reflection on petitioner stop. He did not examine the matter in detail with reference to the original records stop. Though learned judge found that there were some difference in the votes and such difference was an arithmetic error and it does not materially affect the result of election stop. He also observed that Form 20 bears the signatures of the elections petitioner and his counting agents and no such objection was raised. Stop stanza. The submission on behalf of the appellants is that the totality of circumstances have got to be seen and the factum of family settlement along with the contribution to the purchase of the property by appellant number 1 has to be given due weightage. Stop. It was also submitted on their behalf that the appellants are the persons on the spot and they are developing the property and none of the respondents are available there. Stop. The flats are undoubtedly sold in the name of the first respondent because the property stands in his name. Stop. In any case, it is submitted that the nature of powers under documents have got to be examined on evidence with respect to the family settlement and the appellants cannot be non-suited at the motion stage when it was a family dispute and particularly when the sisters who were parties to the family settlement were supporting the submission of the appellants. Stop. The respondents, on the other hand, submitted that this was a fit case to grant the interim mandatory order as was granted by the division bench. Stop. The property belonged to the respondents and it is only because they were not well that the appellants carried out the development thereon. Stop. Now they are taking advantage of the situation. Stop. We have noted the submissions of both the parties. Stop. The question which comes up for our consideration is whether the learned single judge exercised his discretion in such an arbitrary or perverse manner that the appellate court ought to have interfered with it. Stop. The learned single judge has passed a detailed order explaining as to why he was constrained to grant only the limited interim relief. Stop. It was in the interest of both the parties as well as the flat purchasers. Stop. The order passed by the learned single judge is also on the basis that anything beyond the limited protection given at that stage would deny the opportunity to the appellants to establish their case at the trial when it is not in dispute that appellant number 1 contributed 90% of the purchase money to the property and he took steps all throughout to develop the property. Stop stanza. Undoubtedly, there are many inconsistencies in the stories that are put up by both the parties and an interlocutory stage is not the one where one can reach at a definite conclusion one way or the other, particularly where the fact situation is as above and it would result into non-shooting one party. Stop. As far as the order of learned single judge is concerned, it must be noted that it was a suit by one joint owner of an undivided family house to restrain the other joint owners, their heirs, from transferring their share of the house and from parting with possession to a third party purchaser and restraining the purchaser from entering into and or remaining into possession of the suit property. Stop. This was on the basis of the mandate of Section 44 of the Transfer of Property Act and particularly its proviso. Stop stanza. This court went into the question as to whether interlocutory injunction of a mandatory character as against the prohibitory injunction could be granted ? The counsel for the respondents pointed out that the mandatory injunctions were essential to avoid greater risk of injustice being caused. There is no difficulty in accepting that this court did accept that test. The relief of interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo. Over.